My name is Jonathan Wright. I'm an associate in Hunton Kurth's privacy team in the London office. I'm going to speak to you about some of the privacy considerations with using contact tracing technology to fight the COVID-19 pandemic. Whilst the term contact tracing is becoming an increasingly popular phrase in the recent weeks and months, many still aren't familiar with exactly what it involves. In short, contact tracing is used to determine whether an individual has been in contact with an infected person during the period for which they may have been infected. This data can then be used to communicate with those individuals to ensure they take the necessary steps to protect themselves and others. For example, by quarantining for a certain period of time. Contact tracing apps work by using either short-range Bluetooth or GPS technology to trace and alert individuals who have come in close contact with anyone who is being diagnosed with COVID-19. Contact tracing is viewed widely as key to containing the spread of COVID-19, and for this reason, the use of these technologies is becoming more and more widespread, and we're seeing countries around the globe relying on contact tracing as one of the main ways of containing the spread of COVID-19. Whilst contact tracing is key to containing the spread of COVID-19, there are a number of privacy issues to consider before implementing or developing this type of technology. Most notably because these apps may collect certain sensitive data, including location data or information relating to an individual's health or well-being. This has led to a number of European data protection authorities releasing guidance on the use of this technology. For example, the UK ICO has recently published advice for organisations and small businesses that have been asked by the government to collect and retain customer and visitor information as part of the government's effort to ease the lockdown in the United Kingdom. Just because the UK government has asked organisations to assist with its contact tracing efforts, this does not mean that organisations can simply disregard the requirements of data protection law. And it has been made clear by the ICO that any entity engaging in this kind of data collection will need to comply with the requirements of data protection law. And any organisation that is exploiting the health crisis by misusing personal information is at serious risk of enforcement action. As such, organisations assisting with contact tracing efforts or implementing their own contact tracing technology should take care to ring-fence the data collected for these purposes and not use it for incompatible purposes such as direct marketing. One of the key privacy considerations is transparency and the requirement for data subjects to be fully informed about how their data will be used. For many organisations, this will be a new type of data collection and processing, so their existing privacy information is unlikely to cover this use of data. Rather than revising their more general privacy information, organisations may instead wish to consider implementing a supplementary privacy notice which deals specifically with contact tracing and making this supplementary notice available to employees and customers. Ideally, at a minimum, this notice should cover how the data is used, with whom it may be shared, and how long it will be retained. In addition to the transparency requirements of the GDPR, organisations must also give consideration to the purpose limitation and data minimisation principles. With respect to purpose limitation, concerns have been raised about the possibility of scope creep by app developers that may wish to develop functionalities of contact tracing apps to collect additional information for further uses such as marketing. The data minimization principle is of equal importance, and any collection of data should be kept to a minimum. In this context, the data collected should be limited to that which is strictly necessary for the purposes of notifying individuals in the event of infection. And any data retained for these purposes should not be retained beyond a reasonable period, which for these purposes will be the period during which notification of a new infection may be possible. Given the generally accepted 14-day incubation period of the virus, data collected for contact tracing purposes likely can be deleted within weeks. As mentioned earlier, the use of contact tracing technologies may involve the processing of sensitive personal data. As such, it's essential that organisations take steps to keep this data secure. Obviously, this involves implementing appropriate technical organisational measures to prevent unauthorised access, but more specifically for organisations creating apps or contact tracing technologies, this means factoring privacy into the design of their solutions from the outset. This will include initial data protection impact assessments as a minimum requirement, and these impact assessments should be updated on an ongoing basis. For security purposes, many organisations prefer a decentralised approach to contact tracing. In a decentralised system, the matching and tracing of at-risk individuals would occur on an individual's mobile handset rather than via a centrally held database, minimising the risk that a bad actor could access or misuse the centralised data. To wrap things up, and as mentioned before, contact tracing is fundamental to containing the spread of COVID-19. That said, organisations must take steps to ensure they comply with data protection legislation. Thank you for listening, and we hope you found this useful.